my name is Schyler Church. I am a California real estate broker as well as a member of the education department here at Accredited Real Estate Schools. We have posted this video before, but for the first 25 questions of DRE released state exam sample questions. So now we're going to do the last 25 questions of 26 to 50. I'll have that other video linked below if you want to take a look at it. But as always, if you like our videos, make sure to give us a big thumbs up, subscribe to our YouTube channel, and comment below if you have any questions or just comments. We basically use that to gauge, and we'll keep putting more material out the more people interact with our channel. But let's get to it and start with the first question of 26. A broker acting in a fiduciary capacity representing a client in dealings with third persons in selling, buying from, or exchanging real property is said to be bound by the laws of A. Limitations, B. Trusteeship, C. Agency, D. Power of attorney. So a broker, a real estate licensee, they're acting in this fiduciary capacity to their client, where they're representing their client and they have this fiduciary obligation of utmost care, honesty, integrity, loyalty, respect, confidentiality, competence, keeping them informed, all of that good stuff you can think of. So when you are acting on behalf of your client, that is because you have an agency relationship that has been established and you're bound to the laws of agency. So agency is the correct answer, C. 27. All persons are protected by the 1968 Federal Fair Housing Act and have a right to bring suit when A. Acts of discrimination deny them the opportunity to have neighbors who are members of minority groups. B. They are evicted by a landlord for having minority guests in their home. C. Acts of discrimination cause their loan for purchase of a residence to be denied. D. Any of the above occurs. So 1968 is the main federal fair housing law that prohibits discrimination in pretty much all of real estate, whether that is within the appraisal, lending, brokerage, anything with it. Somebody could bring suit if they were discriminated against. And so all of these are, if any of these were to occur, they could bring suit. 28. The chief distinguishing characteristic of real estate when compared to personal property is that it A. depreciates over time, B. is a capital asset, C. can be held in severalty or tenancy in common, D. is immovable. So what is the chief distinguishing characteristic, the main difference between real property and personal property? Our general rule of thumb is mobility. If it is immovable, that usually means it is real property, real estate. And if it is movable, we classify that usually as personal property. But always, this is the general rule. There's always exceptions to it. So D is immovable is the correct answer. 29. Copies of all listings, deposit receipts, canceled checks, and trust records must be retained by a licensed real estate broker for A. 1 year, B. 2 years, 3 years, D. 5 years. So copies of these listings, deposit receipts, just an old name for purchase agreements, canceled checks, trust records, all of that must be kept on file for 3 years. 3 years. A general rule of thumb also, if you don't really know the answer and they're asking you how long, a good guess will be 3 years. Most of the time, 3 years will be correct on a lot of them. Some of those are 2 years. Some might be a little bit more than that, 5 years. But 3 years is a good guess if you don't know. 30. If a contingency is put into a contract, it is important to be specific about the A. nature of the contingency, B. duration of the contingency, C. method by which the contingency will be removed, D. all of the above. So remember, a contingency is a condition precedent to the contract. So if, for instance, you have a purchase agreement to that a buyer is buying the property, a lot of the contingencies they'll put in there are physical inspection contingency, financing, appraisal contingencies. So when those contingencies exist, it's important to be specific about the nature. So what is the type of contingency? Duration, how long will that contingency be in existence? But also, how will it be removed, whether that be active or passive removal? So all of the above. If a contingency is put into a contract, it is important to be specific about all of this, the nature, duration, and method by which it'll be removed. 31. When a loan is fully amortized by equal monthly payments of principal and interest, the amount applied to principal, A, and interest remains constant. B, decreases while the interest payment increases. C, increases while the interest payment decreases. D, increases by a constant amount. So a fully amortized loan, remember amortization is the systematic liquidation of a debt obligation on an installment basis. That is the technical term for amortization, where we get to pay off our debt obligation, our loan, with our monthly payments that we usually do, and we'll be paying off the interest and the principal that is owed. So if we have it fully amortized, our payment will remain the same. So let's say you're paying $1,000 a month in principal and interest. Well, what's attributed towards principal and what's attributed to interest will change within that $1,000 that you're paying with each payment. So with payment number 1, it's going to be pretty much all interest, a little principal. But with each payment thereafter, the amount that is attributed towards principal will increase while the amount attributed towards interest decreases. So the amount applied to principal increases while the interest payment decreases. C. 32, joint ownership of real property by 2 or more persons, each of whom has an undivided interest, not necessarily equal, without right of survivorship, is A, a tenancy in partnership, B, a tenancy by the entireties, C, a tenancy in common, D, a leasehold tenancy. So a type of concurrent ownership they're talking about here. Concurrent ownership, what type of vesting? Could you have undivided interest? Not equal. But there's also not a right of survivorship. So the only thing then that they have is possession. That would be a TIC, tenancy in common. The correct answer is C, tenancy in common, where the only thing they share in common is possession, but their interest does not need to be the same, and right of survivorship does not exist. Now, joint tenancy, that would have been where interest is the same, as well as there is a right of survivorship. And then in the state of California, we use community property, not tenancy by the entireties. 33, a loss in value from any cause is a common definition of A, economic obsolescence, B, depreciation, C, principle of contribution, D, adverse leverage. A loss in value from any cause or from any reason, that is the stereotypical definition of, from the appraisal standpoint, depreciation. Depreciation, B, is the correct answer. So the appraiser is going to be looking at the loss in value from any cause or for any reason that's affecting this property. They'll usually look at it from a physical deterioration, functional obsolescence, and an economic obsolescence standpoint. But it's loss in value from any cause or any reason. Yes, we do have the term depreciation that the IRS lets us take on our taxes for improved income producing properties, but that's a different thing. But that's a little different. But depreciation from an appraisal standpoint, loss in value from any cause or any reason. 34, which of the following is a lien? A, an easement, B, a zoning restriction, C, an attachment, D, all of the above are liens. So remember, a lien falls under the umbrella term of an encumbrance. It limits, burdens, affects the title to property. Well, when something affects the property based on money, that is what we call a lien. It's a fancy name of a lien. So if it's affecting, it's burdening, restricting, or it's limiting, affecting, burdening the title to real property, well, that is a lien. Now, on the other side of an encumbrance, we have a non-money encumbrance. It's based on use. Those are not called a lien. So let's see here. An easement, that is restricting the use. That is not a lien. A zoning restriction, that affects the use. That is not a lien. But an attachment, that is a lien. That affects the title of the property based on money, where they freeze the assets. An attachment is generally classified as a general involuntary lien. 35, of the following, which is the most important reason for a broker to maintain a trust fund account in addition to a regular business account? A, to provide a means of control over the destiny of transactions being negotiated. B, it is easier from an accounting point of view. C, if the bank is responsible for any loss to the trust fund account resulting from embezzlement. D, the consequence which could occur should legal action be taken against the broker. So remember, trust fund accounts are important because they are only ever for client money. So brokers would put client money into that, and trust accounts are better protected, especially if the broker was to be sued. Well, if so, they will be going after the broker's personal and the broker's assets, but the trust account is client money. That is an assets that belong to their client. So that would not be touched. So the consequence which could occur should legal action be taken against the broker, that is one of the main reasons why we like to maintain a trust fund account in addition to a regular business account. So D. 36. If an appraiser finds that the fair rent for a vacant parcel of land is $1,400 per month and the interest rate is 11%, what is the approximate indicated land value? So we are given pretty simple numbers here. They say the fair rent for a vacant parcel of land is $1,400 per month. So we got to figure out what the income is. What is the annual net operating income? But we're not given enough information to figure out what they're actually receiving and what the cost of their expenses are for this parcel. So what we have to do then is basically calculate it based on the information provided. So they say $1,400 per month. We got to solve the I. That is 1,400 times 12. Let's get our trusty dusty calculator out. I'm going to do this with you at the same time. And it's going to be 1,400 times 12. That is 16,800. And then the R is given to us of 11%. So we just calculate this. We take IRV, income, divided by rate equals value. So 16,800 divided by 0.11, that gives us 152,727. And that most nearly is $152,730. So C is the correct answer here. So that is how we solved IRV, because we were figuring out the value at that point. So we take income divided by rate equals value. Now, for state exam purposes, you're going to really remember how to calculate the NOI, that net operating income, because that is the true I in IRV. We were not provided that here, so we just took the scheduled gross income of this parcel of property, and we used that for the I. But most of the time, we're going to be using the NOI. That information, though, was not provided to us. Okay. So let's get to this and start with question 37. Economic obsolescence could result from each of the following, except A, new zoning laws, B, a city's leading industry moving out, C, misplacement of improvements, D, an outdated kitchen. So remember, economic obsolescence has a bunch of names to it. External obsolescence, for instance, that means a loss in value to the property that is outside of the property lines that's causing an issue to your property, a reduction in value due to it. It's a form of depreciation. It's the hardest form to correct as well because it's external to the property lines. So what would be considered economic obsolescence and which would not? The question here is italicized with the except. The state exam will not italicize except, so make sure to really read the questions thoroughly when taking the state test. So which of the following is not economic obsolescence? So let's see here. A, new zoning laws. That is something that is outside of the property lines that could cause you an issue to your property. So that is economic obsolescence. A city's leading industry moving out. That could cause a demand to be affected. So that is a B would be economic obsolescence as well. So that is not the correct answer. C, misplacement of improvements. Are we talking about improvements outside of the property or within the property? Not sure yet. So that one's a maybe. D, an outdated kitchen. An outdated kitchen, that is styling issues within the property. That is functional obsolescence. Will always be considered functional obsolescence. So an outdated kitchen is not economic obsolescence. That is the correct answer then here because it is considered functional obsolescence. Okay. 38. As a real estate broker, you negotiate the sale of a residence. The building appears to be sound and therefore no termite inspection is ordered. However, before the escrow closes, you discover what you consider to be evidence of termite infestation in a closet. Under these circumstances, you should promptly disclose this information to A, no one, as you might be mistaken and disclosure could stop the sale for which you would be liable for the breach of contract. B, first and only to the seller, as it is the seller's responsibility to take whatever action is deemed appropriate. C, both buyer and seller for the appropriate resolution. D, the structural pest control board so that an immediate inspection can be on record and the discrepancies corrected by a licensed pest control contractor. So remember, when you are the real estate agent, you are assisting them with facilitating this transaction. You have a duty to disclose material facts to all parties within the transaction. Definitely, if you discover something that's evidencing evidence of termite infestation, you need to disclose that. You need to disclose it to all parties. That is then up to them to decide what would be appropriate moving forward. So C, both buyer and seller for the appropriate resolution. That is the correct answer. If you do not disclose it, you will be held liable for non-disclosure. And also, you do not have to get the Structural Pest Control Board involved. That is for the buyer and seller to decide what to do going forward. They'll probably want to get a pest inspector out there. And when they file their pest report, that'll be actually recorded with the Structural Pest Control Board and held on file for 2 years. 39, a subordination clause in a trust deed may A, permit the obligation to be paid off ahead of schedule, B, prohibit the trustor from making an additional loan against the property before the trust deed is paid off, C, allow for periodic renegotiation and adjustment in the terms of the obligation, D, give priority to liens subsequently recorded against the property. So remember, first to record is first in right with 3 exceptions: mechanics liens, taxes, and subordinated loans. So that subordination clause in a loan, that trust deed, that allows to give priority to later recorded liens. So those later recorded liens can actually take priority in regards to payoff so basically to get paid off first. So when there's a subordinated clause in the loan, that's saying they're going to give priority to later recorded liens, later recorded loans, for instance, that are recorded against that property. Those later ones will actually have priority of payoff when the subordination clause exists in that trust deed. So D, give priority to liens subsequently recorded against the property. That is the correct answer. Then we have 40. Which of the following factors is least important in the appraisal of an old single-family residence? A, the purpose of the appraisal. B, adaptability of the building to the site. C, physical condition of the building. D, original cost of the construction. So what does an appraiser look at when they're going to be appraising a single-family residence that is significantly on the older side? Well, they are going to get the appraisal and they're going to look at what the purpose of the appraisal is and what scope do they need to do to complete this appraisal. So a purpose, they do take that into consideration. They're also going to look at the adaptability of the building to the site. Does the improvement make sense to the land? And in this case, hopefully, but they do look at it. As well as the physical condition of the building. They're going to look at, hey, the effective age versus the actual age, the economic life versus the physical life of the property. They're going to look at the condition of it. So what's affecting it? Is it in good condition, poor condition? Where are we at on this? So they do look at all 3 of these, but they do not care about the original cost of the construction, because with the original cost of the construction, that is going to be we don't really care about it because the appraiser is going to probably pick the cost approach for this old single-family residence to complete the appraisal. So when they do so, they're going to look at the replacement cost, which is something of the similar utility, same utility of it, and they're going to look at what the cost is using today's building practices and materials if they had to replace the property and depreciate it down to its current condition, as well as add the market value of the land. So we do not care about the original cost of the construction, but they would care about the cost of it of today. 41, a balloon loan is most nearly A, fully amortized loan, B, a partially amortized loan, C, a self-liquidating loan, D, a standing loan. So balloon loan, anytime you think of that balloon loan, that balloon payment, that goes hand in hand with B, a partially amortized loan. Because partially amortized, it looks like a fully amortized loan on its face, where you're paying it off like you would be a fully amortized loan. But the loan schedule is actually going to be due and payable before, when you're paying it, it'll be due and payable before the end of the loan schedule. So if you have it amortized on a 30-year, partially amortized might look at it, but it might become due and payable 5 years in. So that big lump sum payment of the remaining principal that you owe is called that balloon payment. So balloon loan is most nearly attributed to be a partially amortized loan. 42, a contractor obtained a construction loan and the loan funds are to be released in a series of progress payments. Most lenders disperse the last payment when the A, building is completed, B, notice of completion is filed, C, buyer approves the construction, D, period to file a lien has expired. So when these construction loans, you will usually give them in progress payments as they go. But lenders with that last one are probably not going to do so, not going to disperse it until D, the period to file a lien has expired. Because remember, first to record is first in right with those 3 exceptions. So they want to make sure nobody else has a claim to the property that they're going unpaid. 43, a grant deed is recorded in the county where the A, escrow and title company's place of business is, B, seller permanently resides, C, buyer permanently resides, D, property is situated. Anytime you are recording something in the chain of title against the property, it is going to be in the county recorder's office where the property is situated. D, whether that be a grant deed, a trust deed, or whatever it is that you're recording for title on that property, it'll be in the county recorder's office where the property is located. 44, Brown purchased a $14,000 note secured by second mortgage for investment purposes. The seller allowed a 15% discount. The note provided for monthly payments of $1,220, including interest at 9% per annum over a 1-year term. Brown received full payments on the above terms. The yield on Brown's investment expressed as a percentage is. So I'm going to preface this. I know a lot of people advertise there is no math on the state exam anymore. Well, 20 years ago, math was big on the California state tests. They then realized quantitative calculations weren't really as indicative of a student's knowledge. So they moved away from calculations and they went to more qualitative, conceptual based. But there are still some math questions that are in circulation. So the odds of you getting a math question on your state exam is very, very, very low. But you might get 1, maybe 2 math questions. It's not non-existent. That's why when people advertise, there's no math, that's just because it's easier for them. Yes, there could be math on the exam, and some students do get math, but usually it's about 1 to 2 questions. But a lot of the times you won't get any math questions, which is nice. And the good news is this type of math question that we're talking about here is pretty old school. This is something that you would not get on the state exam, okay? This is pretty involved and you do not need to really know how to do this one. But if you're curious, I'm going to go over it with you. Okay, so let's calculate this question. Let's go through this. Okay, so Brown purchased a $14,000 note, but they got discounted to 15%. So the face value of it's $14,000, but he was able to purchase it at the discount. So he got it at 85%. So we times that by 0.85. So 14,000 times 0.85. Again, I have to whip out my calculator. Times 0.85. That gives us $11,900. That is what he paid. And when he paid that, that's what he got for a $14,000 face. Now, the note, remember this is just the IOU. They are going to pay back this $14,000 note with $1,220 payments. That basically includes the 9% interest over this 1-year term. So if they're paying it at $1,220 for 1 full year, which they did, that gives us $1,220 times 12 of $14,640. $14,640 was what was paid. So Brown purchased it for $11,900, but he actually got paid $14,640. So what was his yield? What did he actually profit on this as a percentage? So the best way to do it is we subtract these numbers, $14,640 minus $11,900. So his profit on it was $2,740. We take this $2,740 and we're going to divide that by his initial investment of $11,900. So that gives us a 23% yield on his investments. So the correct answer is A, 23%. Now you're probably very happy to know these questions on the state exam do not really exist anymore. This is very involved. When I took my salesperson exam, yes, we had questions on this. I had square root questions. I had quite a bit of math on my salesperson. But my brokers, I only had maybe 5 math questions. Again, though, I've been licensed for a while, and that's changed now to where if you're going to take your exam, you might get 1-2 questions. But the people that advertise that there's no math on the exam, that is incorrect, because the odds, I would say it's about 60%, maybe 70%, you won't get a math question on the exam. But if you do get a math question, you'll probably only get 1, maybe 2. And the good news is if you do our program, we know exactly what type of math questions are still in circulation. So that's also within our database of practice questions, and we teach that in our live and video program. Okay, moving on to question 45. The covenant of quiet enjoyment most directly relates to A, nuisances maintained on adjoining properties, B, possession of real property, C, title to real property, D, all of the above. So the covenant of quiet enjoyment, that does not mean that you are not going to have loud neighbors, barking dogs near you. But it does mean if you are a tenant and you're renting a property, you have the covenant of quiet enjoyment from the landlord. The landlord cannot interrupt your possession of the property. You have the ability to quietly enjoy that. So if the landlord needs to see the property, they have to give proper notice unless there's an emergency. Also, if the tenant stops paying rent, the landlord can't take it upon themselves to turn off the utilities to try to force them out. No, the tenant still holds that possession. Possession stick, remember, that's why they have a less than freehold estate. So that's why the covenant of quiet enjoyment most directly relates to possession of real property. 46, an interest in real property may be acquired by either prescription or by adverse possession. The interest resulting from prescription is A, the right to use another's land, B, possessory title, C, an equitable interest, D, a private grant. So when we have prescription versus adverse possession, so remember what we like to think here with prescription, we like to think of an easement by prescription, which means the right to use somebody else's property without their permission. So if you're getting it from prescription, it is the right to use another's land. And that's if you've satisfied ouch. It's been open and notorious, uninterrupted for 5 years. You have a claim of right, and it's hostile to the owner's intent. If you satisfy ouch, you have gained the right to use somebody else's property. Whereas once you satisfied ouch, but you also paid for 5 years property taxes for it, you've added the T of taxes. Well, you've actually now gained the T of title. So when ouch becomes touch, that is adverse possession, and somebody can actually then gain the title to the property, somebody else's property, without their permission. But here they're asking about prescription. And remember, prescription, that is the ability to use another's land. 47, generally the taking of private land by governmental bodies for public use is governed by due process of law and is accomplished through A, exercise of the police power, B, eminent domain, C, reverter, D, a sheet. So what are the 4 sovereign powers of the states? Taxation, police power, eminent domain, and a sheet. Those are the 4 sovereign powers of the state. And one of the sovereign powers lets the government take private property. So from private landowners, they can take that property as long as it's for the public good under due process, and they provide fair and just compensation to the landowner. They are allowed to do this. The government is allowed to do this through the sovereign power of eminent domain. Eminent domain is the power that allows them to take this private property for public good with that fair and just compensation. The taking of the property is through a condemnation action, which results in an involuntary conversion. But the power is eminent domain. 48, governmental land use planning and zoning are important examples of A, exercise of eminent domain, B, use of police power, C, deed restrictions, D, encumbrances. Remember, so zoning, whenever we think of zoning, the first thing we should come into, so how are these cities and counties allowed to impose zoning on us? Because this is a public restriction. This public restriction they're allowed to impose on us because of the power of police power. Use of police power. So police power is not like cops and sheriffs. This is within constitutional limits that the state has the ability to enact laws for our well-being of our society. So one of the things that they can do then is zone our parcels of property. And why do they zone? That is also to implement the general or master plan. So governmental land use planning and zoning, those are important examples of the use of police power, one of the sovereign powers of the state. 49, most contracts between a seller and broker for the purpose of selling real estate in the form of A, general power of attorney, B, novation, C, a written agreement, D, an assignment. So remember, they're talking about here like a listing agreement. If we are going to be representing a seller, we like to get that listing agreement, and that listing agreement will state our warranty of authority to actually be their agent. It establishes actual authority. And the best way to do it, so that's why it's the most common way, is for it to be in a written agreement. C, written agreement. Now again, the state exam is a big vocab test. You should know your vocab. So before I even talk about general power of attorney, novation, or assignment, you should be able to know what these are and that they have nothing really to do with this. Because general power of attorney, that's where, if that was established, that means that the agent can actually be the seller, sign for the seller. No, that's not the case. Novation, that is just a term for substitution of something new for something old. So if we are substituting a new listing agreement with an old listing agreement, that'd be an example of novation. As well as assignment is just transferring all of the rights and obligations to someone else. So those do not deal with this. But for listing agreements, most of them are going to be in the form of C, a written agreement. And the last question here. In arriving, number 50, at an effective gross income figure, an appraiser of rental property makes a deduction for A, real property taxes, B, repairs, C, vacancy, D, depreciation. So effective gross income. So that appraiser's looking at that income approach. They're going to take the scheduled gross income. If life was perfect and everybody paid rent, everything was rented up, well, they are going to make a deduction for what they're actually collecting. So they're deducting for vacancy. So they'd make a deduction for vacancy. So to get the effective gross income, we subtract vacancy from the scheduled gross income. That's where we get our EGI. If we had to take it a step further, though, to get the I in ER for the formula, we would take that effective gross income and then we would subtract for the operating expenses, the cost to actually run the property. And that's then when we get our NOI, and that would be the I in ERV. But here they're just asking, how does the appraiser come up with the effective gross income? That is what they're actually collecting, so they make a deduction for vacancy. Thanks for watching. I hope this video was helpful in your licensing journey and your studies. If you liked it, make sure to give us a big thumbs up, as well as subscribe to our YouTube channel so we keep producing new content. But if you have any questions, or if you'd like to check us out for completing coursework to be eligible to take the state exam, or even for preparation to help you prepare for the state test, we have tons of options, and I have our website listed below. Otherwise, I'm Schyler with Accredited Real Estate Schools, and thanks for watching.